before we go on, I should say that for reasons that are obvious to anyone who was in the hearing room yesterday afternoon, I have excused Mr McMaster further attendance. If he were later to seek an opportunity to give further evidence to me, I would of course consider that application. And of course, he will have leave to make submissions in response to any matters that counsel assisting may raise. One matter that needs to be completed just to regularise the transcript. There was a document about which Mr McMaster was being examined when he fell ill, and that document should be marked as an exhibit. Exhibit 2.245 will be Dover's Client Protection Policy, ASIC 0022 0001 11227.
Thank you, Commissioner.
Thank you, Mr Costello. Ms Orr.
Commissioner, the final witness in this hearing block is Louise Macaulay.
Ms Macaulay, can I ask whether you'd prefer to be sworn or to make an affirmation?
To make an affirmation.
Do you mind standing, please, and affirm Ms Macaulay?
I solemnly and sincerely declare and affirm
that the evidence I shall give will be the truth,
the whole truth,
and
nothing but the truth.
Thank you very much, Ms Macaulay. Do sit down. Yes.
Your full name is Louise Ann Macaulay?
Yes.
And you, your business address is Level 5, 100 Market Street, Sydney?
Yes.
And you are Senior Executive Leader of ASIC's Financial Advisors team?
Yes.
And you've received a summons to appear here today?
I have.
Do you have a copy, do you have the original of that summons with you in the witness box?
Yes.
I tender that document.
Exhibit 2.246. Yes, Exhibit 2.246 will be summons to Ms Macaulay.
And Ms Macaulay, have you prepared a witness statement dated the 25th of April 2018?
Yes.
And that witness statement is a corrected version of an earlier witness statement that you prepared, which was dated the 13th of April 2018?
That's correct.
And the corrections made from that earlier version are confined to changes to some figures in the tables at paragraphs 20 and 43 of the statement?
That's correct.
And do you have the signed original of your witness statement dated the 25th of April 2018 with you?
Yes.
And is the contents of that statement true and correct to the best of your knowledge?
It is.
I tender the statement and the exhibits to it.
Exhibit 2.247 will be the statement of Ms Macaulay, 25 April 18, and its exhibits. Thank you very much. Ms Orr.
Ms Macaulay, you're the Senior Executive Leader of ASIC's Financial Advisors team.
Yes, that's right.
Could you explain what the work of that team is?
So we regulate the provision of financial advice by financial advice licensees and by the individual advisors who provide that advice. We regulate mainly in the area of the provision of personal advice to retail clients on complex products, but we also look at general advice that is provided.
So how many people are in ASIC's financial advice?
At this point in time, there are 60 people.
You've provided the Commission with a statement dealing with the regime for taking disciplinary action and making banning orders against providers of financial advice.
That's right.
How does ASIC become aware of misconduct by financial advisors?
There's a number of ways in which we become aware. Reports of misconduct that come from members of the public or from other financial advisors. Notifications under Section 912D of the Corporations Act, so breach notifications. Some of the material we come across during the course of our own surveillance and through other sources of market intelligence. We get information from FOS as well. Sometimes we get information from industry associations.
And how can a member of the public report misconduct of a financial advisor to ASIC?
So on ASIC's website, there is an electronic form that can be filled in and submitted.
On average, how many complaint conduct by financial advisors does ASIC receive from members of the public each week?
I've got the figure for the financial year 2016 to 2017, and reports of misconduct in relation to financial advice was 170. So that's slightly more than 3 each week.
And each of those was a report by a member of the public, is that right?
It could have been by another financial advisor. Sometimes a member of the public goes to another financial advisor and that person makes a report.
And how many of those reports of potential misconduct does ASIC investigate?
It's about 40% for the last financial year.
And on average, how many notifications of potential misconduct from financial services entities does ASIC receive?
So in terms of breach reports, the figure for last financial year was 106.
And how many of those does ASIC investigate?
About 46%. And so this is generally speaking in relation to financial advice. It's not pertaining just to financial advice.
And how does ASIC decide which reports of potential misconduct it will investigate?
So we look at a number of factors. We look at the seriousness of the misconduct, the impact that it has on consumers. We look at the material that we're provided with in making our initial assessment. We look at the age of the conduct. If conduct happened a number of years ago, that's not perhaps quite as persuasive of conduct which is ongoing and needs to be stopped. We also look at what our strategic priorities and the areas of risk are at the particular time, and whether that fits into those areas of risk or whether it fits into another area where we want to perhaps look at matters with a view to providing some kind of general deterrence message to the industry.
And what are ASIC's current strategic priorities in relation to misconduct by financial advisors?
So it is around professionalism and training. So we would look at misconduct that relates to lack of skills, lack of monitoring and supervision around financial advisors. We're interested in complex product advice being provided under a no advice or a general model advice. We're looking also at self-managed superannuation fund advice. We've got a stream of work in relation to life insurance and advice that is provided around that. We're also concerned about advice in relation to super and which may have an impact on super.
You mentioned areas of risk as well as strategic priorities. What are the areas of risk that ASIC is interested in at present?
Well, those are the areas that we see are risky.
The areas that you've just mentioned?
Yes.
And is there any obligation on financial services licensees to report misconduct by their employees or authorised representatives to ASIC?
Well, it depends on whether it fits within the provisions of the legislation. So it needs to be a significant breach, and whether a breach is significant will depend on the nature of the breach and also on the nature of the licensee. So if it's one advisor within a small licensee and there's been a breach that's affected a number of clients, the licensee may say that that is a significant breach. If it's a large licensee and there is one advisor with a limited number of clients, the licensee may form a view that that is not significant, because a significant breach aspect relates to the conduct of the licensee's business, not to the conduct of the individual advisor.
We've heard references throughout these hearings to communications with ASIC about serious compliance concerns and other compliance concerns. Can you explain those concepts and the origins of those concepts?
Yes, so those concepts are concepts that were developed by ASIC as labels for certain types of conduct. We use them in our advice compliance project, where we were looking at the 4 big banks and AMP, the 5 largest financial institutions, and their conduct around monitoring and supervising licensees. And we wanted to engage conduct around monitoring and supervising advisors, and we wanted to engage with them around how they found poor performing advisors in their business, and to find out from them who the poor performing advisors in their business were. So we asked them to provide us names of advisors whose conduct had fallen within those 2 definitions.
Is there any obligation on a financial services licensee to notify ASIC where the conduct of one of its employees or authorised representatives is viewed by them as constituting a serious compliance concern or an other compliance concern?
No, their obligation is under Section 9 of the Corporations Act.
And do some entities voluntarily notify ASIC where they have serious compliance concerns or other compliance concerns about their financial advisors?
Yes, they do.
And which entities do that?
It's really the 4 big banks and AMP. We also get some from Macquarie Bank, so larger entities that we have engaged with.
And do you sometimes serve notes which have an element of compulsion, asking entities to provide you with information about serious compliance concerns and other compliance concerns?
We did in the context of our advice compliance project, and it may be the case that subsequent to that project we are following up. When we follow up on a number of advisors, we will serve a notice around those individual advisors to gain more information.
There's also the requirement that you've referred to in Section 912D of the Corporations Act to report significant breaches of the general conduct obligations in Section 912 capital A. The introduction of the significance requirement in 2003 transformed what was previously an objectively based self-reporting obligation into a subjective one. Is that right?
Yes.
So licensees currently get to make a judgment about whether a breach is a significant one or not.
That's right.
And the factors that the Corporations Act tells them they need to consider in deciding whether a breach is significant or not involve financial impact of the conduct on consumers, of consideration of non-financial impact on consumers. Is that right?
That's correct.
And ASIC has recently recommended that the significance requirement be retained. Is that right?
Yes, I believe so.
But that the legislation be amended to ensure that the significance of breaches is determined objectively instead of subjectively.
That's right.
And do you understand how that objective test is to work?
Not in detail.
Is it the case that the position that ASIC is pressing for is that a breach will be significant if there are sufficient facts or information to found an objectively reasonable belief that the matter should be reported to the regulator?
Yes.
And ASIC has also recommended that the time frame for reporting a breach under Section 912D be extended to 30 days.
Yes, that's correct.
And that the 30-day period is to run from when the licensee becomes aware of or has reason to suspect that the breach has or may occurred.
Yes, that's right.
And why has ASIC made that recommendation?
We find that there's often a delay in matters being reported to ASIC because it takes some time for a licensee to form a view. They undertake an investigation. I think the provision at the moment says a breach has occurred. So this test is a broader test of when you form a view that there has been a breach or there may well be a breach. It allows a little bit more time for the licensee to do some internal investigation and form their view. We hope that what it will allow is more information to be provided to ASIC at the time that the breach report is made.
Has ASIC ever prosecuted a licensee for failing to comply with the existing 10-day time limit for reporting a breach under Section 912D?
Not to my knowledge.
And why not?
We've certainly looked at it and we've obtained advice from senior counsel on that. There is a quite high evidentiary standard that would relate to that, and crucially the advice focused on the fact that the person who makes the decision about whether or not there's a significant breach can be a person quite senior within an organisation who may not become aware of the information until it's presented to them. So that allows for a licensee to undertake a considerable investigation and in some occasions put in place a remediation program before they put together information and provide it to that decision maker to make a decision. So what that means is a period of months can elapse between the licensee becoming aware of the conduct and it formally making a decision about whether or not it's a significant breach.
And is that a satisfactory situation in ASIC's view?
It is not.
Ms Macaulay, do you know whether any consideration has ever been given within ASIC to, in effect, testing where the bounds of 912A and D would be set by a court?
Commissioner, it has to the extent that we sought that opinion from senior counsel. My understanding is that based on that opinion, we decided that we wouldn't test it in its current form and we would seek to agitate for some law reform.
Is a consequence of the view that was expressed in that opinion that the operation of 912D and reporting is affected by the internal administrative steps taken by the licensee?
Yes, that's my view.
In particular, is a consequence of the view expressed that according to the way in which the licensee orders its own internal administration, the Act may not apply until a particular organ of the licensee forms a view?
Yes.
Understanding that there is change in the wind following the enforcement review, and that ASIC has made the submissions it has in relation to that. It is an unusual position to arrive at, isn't it, that the operation of the law depends upon the way in which those governed by the law organise their own internal affairs?
Yes, that's my view.
Yeah.
Ms Macaulay, you say in your statement that ASIC does not expect that all misconduct should come to its attention. Why not?
Because there's some misconduct which doesn't require the more serious consideration that a regulator would give it around doing a surveillance for a banning. So there may be some misconduct that does not cause any loss to clients, which is not a breach of the law, but is a breach of a licensee's internal practices. It may be that there's an occasion where there is an advisor who gives a piece of non-compliant advice in a situation where advice is otherwise correct. You need to allow for human error and mistakes. There's also the fact that there is internal dispute resolution mechanisms required by each licensee, and then there's an external dispute resolution process that's designed to deal with those sort of isolated situations. In my view, the regulator should become involved when there is serious misconduct which requires consideration of whether there should be some kind of outcome.
And is ASIC satisfied that all serious misconduct comes to its attention?
No.
And what is ASIC doing about that?
So we engage a lot with the industry around their obligations to breach report and the significance of that. We also talk a lot to industry about reference checking and the need to manage the risks of taking on advisors who are known to be poor. We engage with industry associations wherever we can to understand what the issues and likely areas of risk are.
So I think what you've just described is consultation and engagement with industry, is that right?
Yes.
That's what ASIC's doing in response to the problem of not all serious
That's the best answer I can give at this point. There may be something else that I'm not thinking of.
Is ASIC exercising its powers to take action against financial services entities who have not brought misconduct to ASIC's attention?
Yes, so we certainly look at the compliance and surveillance capabilities of licensees. So, for example, the report that I've mentioned previously, our advice compliance report, but we also look at it in relation to other individual licensees. So they may come to our attention through looking at an individual advisor, and then we find concerns that we think need to be more broadly followed up with the licensee. So questions around why didn't the licensee know about the misconduct of the advisor, what other misconduct is occurring within that firm, are they properly monitoring and supervising it? So we've taken action against licensees in relation to that. So licence conditions, for example, were imposed on My Planner. Recently, we took an EU from an entity called NEO, and again, it was founded on their lack of supervision and monitoring and, I guess, discernment of misconduct on the part of their advisors.
Where ASIC does make a decision to investigate potential misconduct of a financial advisor, you say in your statement that establishing that the advice is non-compliant is a resource-intensive process.
That's correct.
Could you explain that?
Yes, I can. So when the information comes to ASIC that there's an advisor who's engaged in misconduct, or we've come across the information, we need, well, first of all, we are always making choices about which matters we take on and which matters we don't take on, given our limited resources and the range of notifications of misconduct that we have. What we will typically do is serve notices on the licensee, so we will seek 10 or so files of the advisor's advice. Sometimes we have to serve notices on several licensees if the advisor has moved around. We'll then do an analysis and assessment of those files. As a rule of thumb, it takes about 1 day to do an assessment of a file. We will look at other sources of information, so we might serve a notice on FOS. We might have a look at the advisor's complaint register to see what other complaints may have been made against the advisor. In some instances, we will speak to clients. In some instances, we'll speak to advisors. Then, based on our analysis of all that information, we'll form a view about whether we should take some further regulatory action. In most cases, that would be preparing a brief to an ASIC delegate seeking either a temporary or a permanent banning of that advisor. That brief needs to be put together. It's essentially a set of observations or a narrative that sets out what we think has occurred and where the concerns are, and then it's supported by all of the material behind it. So depending on the matter, that can be voluminous and it may require more or less analysis depending on the nature of the advice. Then it is submitted to an ASIC delegate who reads that material, makes an assessment of whether or not they think there is a basis for serving a notice of concern on the advisor, and then that initiates the hearing process. There'll be a hearing where can come and make submissions, or written submissions can be made, and then the delegate will make a decision based on that material and submissions from the advisor.
I want to ask you some questions about that banning order process, but before I do that, given the resource-intensive nature of that process, if more serious misconduct came to ASIC's attention, would ASIC have the capacity to deal with that misconduct?
Not on our current resources, so we would need to engage in some kind of assessment of where those resources may come from.
Just to understand better than I presently do what you say about resource-intensive investigation, it occurs to me, at least at the theoretical level, perhaps at the unduly practical level, there would be cases where the poverty of the advice would be self-evident.
That's correct.
In the context of a former life and sentencing appeals, they're the jaw drop tests. The advice that is given simply couldn't have been thought through. Is that right?
Yes, that is correct.
Does it remain a resource-intensive process even in those cases? Or is it resource-intensive in the disputed and disputable cases?
Well, nature, how resource intensive it is does depend on the information. We find even in the jaw-dropping cases, Commissioner, defences are put on, material is provided that was not provided to ASIC in an attempt to explain why the advice was correct advice, or other extraneous information is put before the delegate.
I'm not in the least surprised by that, but that's responding to the answer that is made. I'm just a little anxious to understand better than whether I should be approaching this as how can I put this, as a blanket problem, or as a problem where there is a range of possible cases where, of course, any regulator has to determine how it's going to apply its resources. And can I just leap ahead about 5 steps to indicate what's troubling me? It's the notion of the regulator taking steps overtly to demonstrate that bad conduct will be called out and dealt with. Again, to hark back to the radically different field of discourse of the criminal law generally, it's the notion of public denunciation. That somebody is charged with an offence under the ordinary criminal law for various purposes. One of them is to publicly denounce conduct of that kind. Now, what I want to grasp better than I presently am now grasping is whether that sort of idea, the public message, plays a part in the way in which ASIC is approaching these issues.
I think you can probably say that it doesn't at the moment. There are constraints on what we can publicly say about bannings. It's our investigations and surveillances, of course, are private, and then the banning process also takes place privately, and the decision is also private, and so we can and we do always put out media releases which record the order, and we do have some brief explanation of the misconduct. So those constraints apply as a result of procedural fairness. We do, in the reports that we prepare and publish, put in there examples of behaviour that we have come across, and they are real-life examples and they are anonymised. And so they don't relate to the individual advisor, but they do give an idea of the kind of conduct that we are seeing.
Yes.
I want to ask you some questions about banning orders, Ms Macaulay. Who can be the subject of a banning order?
An advisor. We do occasionally do banning orders against people who are no longer in the industry, but generally we only do them against advisors who are in the industry.
And what type of conduct can result in a banning order?
Well, a range of conduct. So to start with, if there has been criminal conduct, we would take a banning order, we would apply for a banning order. We would also look at criminal proceedings. And then in terms of what is, so that'll be some kind of dishonesty matter. Other things that support a banning order will be generally around the provision of poor advice. It may be a lack of training and education, so an inability to provide advice. We have looked in some cases around issues of the client's signature being applied by the advisor to documents.
A banning order can be permanent or for a specified period, is that right?
That's right.
And what's the average duration of a banning order that's made for a specified period?
Well, it's about 4 years. So the banning orders that have been made this year, the average has been 5 years, but it's about 4 years.
And how long does it generally take ASIC to make a banning order after being notified of potential misconduct by a financial advisor?
Well, from the time, I'll answer that question in two ways. From the time that we have made a decision that we're going to commence looking at an advisor for the purposes of taking some action, it takes somewhere between 6 and 12 months, probably at the upper end of that. And if it's serious misconduct, criminal misconduct, leaving aside any criminal brief, it will take a little bit longer than that to get to the stage of putting the brief to the delegate, and then it will take on average about 5 months for that delegate's decision to be made. And the second part of the answer to that question is that's at a point of time where we decide to go ahead with some kind of surveillance. That won't be immediately that the information or the report of misconduct hits ASIC. In some cases, we will be waiting to get some further information from the licensee. So we might get some information under a breach report. The licensee is undertaking further investigation. So in some instances, we may wait to get that information. In some instances, we may not have the resources at that point in time to commence the surveillance of the licensee, but it's one that we want to do, so we'll have to wait till we can shuffle around resources or resources become free.
That first period is the period between being notified of the conduct and making the decision to commence an investigation into the conduct.
That can vary. In some instances, it can be a couple of months. In other instances, it can be longer. So other situations are where we become aware of misconduct, but the advisor is no longer in the industry. So we set that matter aside and we wait. And if we hear, we understand from the financial advisors register that the advisor re-enters in the industry, then we might start. So, it could be, it could be any length of time up to a year.
So 2 months to a year to make the decision to commence an investigation, and after that point, 6 to 12 months to get the brief to the delegate,
That's right.
and after that point, about 5 months for the delegate to make the decision.
That's correct.
Just so I understand, the purpose of a banning order is protection of the public,
That's right.
but it might take a couple of years before ASIC gets a banning order for that purpose after being notified of potential misconduct.
That's right.
Is that satisfactory, Ms McCauley?
No, it's not.
And what is ASIC doing about that?
Well, resources is part of the answer to the question. We are engaging with licensees about more prompt reporting of misconduct and provision of internal material that they have that supports a banning process.
So that relates to getting the information to
That relates to
you,
getting the information.
but what is ASIC doing about the time that
Internally?
it takes? Yes.
Internally, so we have templates, so we attempt to speed up the process of preparing the brief by trying to organise it in the most efficient and effective way. How long it takes to do a surveillance depends on what resources we have available to do it. If a person is doing 5 of these matters at one time, it takes longer than if they're doing, say, 3. The challenges are we seek material from licensees or other sources. It may take some time to get that material. When we get that material, it's not always everything that we ask for, and so we have to sometimes serve a series of notices. The analysis can take some time. So we have improved and worked on our skills in putting together the material and drafting the delegates' brief. We've engaged with the delegates to understand exactly what it is that they want in the brief, so that to them the best brief that is possible to get. Again, the time that a delegate will take to conduct the hearing is influenced by any requests that an advisor makes for extra time before the hearing is conducted, and sometimes several of those requests can be made, and so it can take some months before we can get the advisor to appear at a hearing, or we make a decision that we will just go ahead with the hearing.
In what circumstances does ASIC have to provide notice of the banning order application to the person who's the subject of the application?
When the delegate has had a look at the material and formed a view that there is that material supports the basis of concerns that have been outlined to that delegate, and then it's provided to the advisor.
I see. So that's another step in the process. The brief
Yes.
is provided to the delegate.
Yes.
The delegate forms some views about whether notice should be given to the person, the subject of the application.
Well, notice is always given to the person because that's part of the procedural fairness obligations. The delegate makes a decision about whether they think on the material provided to them there is, in a sense, a prima facie case. There's a basis upon which to make a banning order, and once that threshold is passed, the material is then sent to the advisor.
And the advisor has a right to appear at a private hearing before the ASIC delegate?
Yes, that's correct.
And to make submissions to the ASIC
Yes.
delegate? And how does the hearing before the ASIC delegate work?
It's a private hearing. It takes place in ASIC's offices. There are transcription services. Very often an advisor will come along with some legal representation, and the advisor is given an opportunity to make submissions as to why essentially they shouldn't be banned. And often subsequently there are written submissions as well provided. And so the delegate will ask questions of the advisor, and the advisor has an opportunity to put, I guess, their case in answer to the brief of material provided to them.
And does a representative of ASIC appear before the delegate to challenge or respond to the contentions made by the advisor?
No, it's not an adversarial process, it's an administrative decision-making process.
Can a delegate's decision to ban an advisor be challenged by the advisor?
Yes, it can. So the Administrative Appeals Tribunal has jurisdiction, so that's a merits review, and there's also the ability to go to the federal court subsequently for a review on a question of law.
Do you know how long it generally takes for matters to work their way through the Administrative Appeals Tribunal on a review?
Generally speaking, about a year.
And if the matter is taken to the federal court, do you know how long it generally takes for the matter to work its way through that process?
No, I don't. That is not it's a very occasional occurrence.
Can a delegate's decision not to make a banning order be challenged by ASIC?
Not practically speaking, because it is a decision of ASIC.
Are there limitations on the scope of banning orders?
Well, yes, there. So, a banning order can be made permanently. So, to that extent, there's no limitation on the scope of it. It generally is made in terms of an order provides an inability to provide financial services either permanently or for a set time. I'm not sure if it's the case that some kind of conditional cessation or suspension order can be made, but that's generally not made by a delegate.
Can the delegate ban individuals not just from providing financial advice or financial services, but from managing a financial advice or financial services firm?
No.
Is it satisfactory that ASIC doesn't have the ability to do that?
It's not satisfactory.
And the ASIC Enforcement Review Task Force has recommended that ASIC should be able to ban a person from performing a specific function or any function in a financial services business.
That's correct.
And last week the government agreed to that recommendation.
That's right.
Now, just coming back to the purpose of banning orders, you said in answer to my question before that it was about protection of the public. Is it also about punishing poor conduct by advisors?
The AAT and the courts have said there is a deterrence element to those sorts of decisions. The practical effect of it is that it does provide punishment because it takes away the advisor's livelihood. But as I understand it, precedent is that it is protective of the public.
Mm-hmm. And in your statement, you've provided the Commission with some statistics on the number of banning orders made by ASIC in the last 10 years.
That's right.
You've set out a table in your statement at paragraph 20. So the top table we see there is the number of banning orders made in respect of financial advisors, and the second table is the total number of banning orders, which includes the banning of company directors and others. Is that right?
No, it's not. It's only banning orders under Section 920A, so it's in relation to financial services.
So who are the others who are not financial advisors who are captured by the second table?
So insurance brokers, it may be people who've run an unregistered managed investment scheme. Sometimes we include in that table stockbrokers if the misconduct is just in relation to stockbroking conduct.
So we can see from the first table that since 2008, ASIC banning orders, actual advisors, how many of these were permanent banning orders as opposed to orders for a specified period of time?
So 46% of them were permanent.
And the year in which most banning orders was made is 2016, when 36 financial advisors were banned.
That's correct.
And as at the date of your statement, 10 financial advisors have been banned this year.
That's correct.
You heard Mr. Kell's evidence that there are approximately 25,000 financial advisors in the industry.
Yes.
And are you aware of the evidence in these hearings about the different types of misconduct engaged in by financial advisors across multiple licences?
Yes.
Do you think that ASIC has used its banning powers enough to deal with misconduct in the financial advice industry?
No, I don't think that we have. I think we have used them to the best of our ability, given our resourcing levels and the other areas in which we need to regulate financial advice.
How many of the 229 banning orders were the subject of an appeal to the Administrative Appeals Tribunal?
86 were.
And how many of those 86 resulted in the banning order being varied or set aside?
In 21 cases, I say in my statement.
And you say that 17 of those were varied and 4 were set aside, is that right?
That's right.
You say in your statement that ASIC can also take proceedings against a financial advisor.
That's correct.
How many civil penalty proceedings has ASIC instigated against a financial advisor in the last 5 years?
None.
Why is that, Ms Macaulay?
So several reasons. First of all, a civil penalty order can't include a banning order, so it doesn't have that immediate protective effect. So we would need to do a banning as well as a civil penalty order. Now that can certainly be done. We have looked at doing a civil penalty order, a civil penalty action against individual advisors. We've decided not to do it in the particular instance I'm thinking of. It was in the context of a broader civil penalty action. It was the first civil penalty action taken, so we wanted to just focus on the action against the licensee. But one aspect that we would consider is, having banned the advisor, what is the utility, and also taking a civil penalty action with time and will be costly in terms of resources, and measuring or balancing the value that we would get out of that against the value in perhaps using those resources to ban another advisor that we are aware of who is providing poor advice to consumers.
What about the utility in public denunciation of that advisor's conduct, both as a measure for deterrence of that advisor and general deterrence of advisors in the industry engaging in similar sorts of conduct?
Yes, and I agree that is a weighty consideration.
But ASIC has not commenced any civil penalty proceeding, despite having the power to do so since 2013?
That's correct.
And that means, as I understand it, that ASIC has not instigated a single civil penalty proceeding against a financial advisor for breach of the best interests duty in the Corporations Act. Is that right?
That's correct.
And is that satisfactory, Ms Macaulay?
No.
You say that ASIC can also seek corrective action in relation to financial advisors by engaging with the licensee responsible for their conduct?
That's correct.
What sort of corrective action are you referring to there, Ms Macaulay?
So part of the corrective action would be providing remediation to the clients, but there would also sometimes be corrective action in relation to... Sorry, I'm just refreshing my mind from my statement.
You deal with this in paragraph 31.
That's
if it
right.
assists, Ms Macaulay.
So that would be in a circumstance where we were confident enough in the licensee and their ability to supervise and monitor to engage with them to impose some kind of enhanced supervision regime in relation to the advisor. So vetting of all advice, having the advisor shadowed by a more senior or another advisor to ensure that the engagement with the clients was correct, and doing a remediation program looking back at the advice that the advisor had provided in the past and correcting any loss that that advice had caused.
But presently you don't have any power to require a licence take that sort of corrective action?
That's right.
And your Enforcement Review Task Force has recommended that ASIC does have a power to direct financial services licensees in the conduct of their business where necessary to address or prevent risk to consumers.
That's right.
And the government has accepted that recommendation in principle, but said it will consider the recommendation in conjunction with any findings from this Royal Commission. Is that right?
Yes, that's right.
You also statement that ASIC can enter into enforceable undertakings or negotiated outcomes in relation to financial advisor misconduct.
That's right.
Why does ASIC negotiate with financial services entities about sanctions for financial advice misconduct?
We would do so in circumstances where where we've got a matter underway, we're looking at the advisor with a view to taking some kind of banning action. The advisor approaches us and essentially makes an offer. We would consider that offer. We take enforceable undertakings where we think it would give a better outcome than the alternative, in this case administrative proceeding. So we would accept an enforceable undertaking in circumstances where what was offered to us was better than we thought we could get before a delegate, and an example of that would be a period out of the industry that we thought was a realistic assessment of what a delegate might decide to impose, plus something else such as before re-entering the industry, further education would be undertaken, or there would be an arrangement with the licensee that there would be pre-vetting of the files.
What are the consequences if you enter into an enforceable undertaking with a financial advisor and they breach the enforceable undertaking?
So an enforceable undertaking is enforceable before the court, so we would need to go to the court and get an order. And I think there's a range of orders, including obliging the advisor to engage in the conduct that they undertook to engage in.
And does ASIC supervise the implementation of the work that's required by the enforceable undertaking of the financial advisor?
Yeah, we do to some extent. We tend to monitor enforceable undertakings more closely in relation to licensees, but we certainly look very closely, for example, if an advisor has come back into the industry and they've promised that they will do some further education before they come back into the industry, we would check that.
ASIC has a power to disclose information about specific financial advisors to the relevant licensee, is that right?
Yes, 916G, yes, that's right.
And you tell us in your statement that that power is rarely, if ever, used.
That's correct.
Why is that?
We need to be reasonably satisfied about the information before we release it, and usually that involves us undertaking some kind of surveillance. If it relates to the compliance or the abilities of the advisor, we need to satisfy ourselves that there are some issues there. Practically speaking, very often in the course of doing that, we will be serving notices on the advisor's licensee, and so the advisor would become aware of that through the notice. There has been one occasion, the only occasion I'm aware of, where we released information, and it didn't relate directly to the ability of the advisor, but it was information in relation to a substantial betting account that we'd become aware that advisor held, and we felt, whilst it had no relationship to the provision, or there was no link between that and his financial advice, we thought it was a significant risk factor that the licensee should be aware of.
And that's the only instance that you're aware of where ASIC has exercised that power to disclose information to the licensee?
That's correct.
ASIC also has a power to disclose information about advisors to prescribed disciplinary bodies. Is that right?
That's right.
And neither the FPA or the AFA, the two financial planning industry bodies, is a prescribed disciplinary body.
That's correct.
Why not?
I don't know the answer to that question. It's not something that I've looked at. I suspect it may be because they don't have, significant indicia to meet the standard of a professional body that would be required, but that's just speculation on my part.
Does the current regulatory structure mean that misconduct by a financial advisor is predominantly dealt with by the licensee?
Yes.
And is that a consequence of the way the financial advice industry has developed?
Yes, but it's also a consequence of the way that the legislation is currently constructed.
And is it appropriate, do you think, in a professional or quasi-professional industry for a large amount of the disciplinary power and responsibility to be left with the bodies who profit from the work of the financial advisors?
No.
Other professionals, such as doctors and lawyers and dentists, tend to be individually licensed. Are you aware of whether any consideration has been given to requiring financial advisors to hold individual licences rather than for the licensing to be at the entity level?
No, I'm not aware of that.
Do you think there should be consideration of that, Ms Macaulay?
Speaking personally, yes, I think there should, and there's certainly been broader discussion within the industry around that possibility, but though that is a large policy question, and the place that would be discussed would be within Treasury.
And what would be the advantages, in your view, of individual licensing of financial advisors?
Well, you wouldn't have the intermediary, the licensee. It would be a direct obligation on the individual. They would need to meet the professional standard. If they were unable to do that, then they would be out of the industry. So, yeah, it would be a more direct form of regulation.
Has the movement of financial advisors who've engaged in misconduct between licensees been a problem in the industry?
Yes.
And you're aware of the ABA protocol that deals with that?
Yes, I am.
Perhaps if we could have brought up RCD 0021 0003 0024. You're familiar with this document, Ms Macaulay?
Yes.
This is the Financial Advice Recruitment and Termination Reference Checking and Information Sharing Protocol, which is current, having been promulgated in September 2016.
Yes.
I tender that document, Commissioner.
Exhibit 2.248 will be ABA Financial Advice Recruitment and Termination Reference Checking and Information Sharing Protocol 20 September 16, RCD 0021 0003 0024.
Does this protocol, in your view, Ms Macaulay, fix the problem of financial advisors who've engaged in misconduct moving from one licensee to another?
No.
Why not?
It only, ABA members are the only people who can become signatories, and the obligation on signatories is only to provide information to other signatories. That's a very small part of the industry, 95% of licensees, of the ABA, so there's no obligation. That applies across the industry. I think, secondly, the protocol recognises that there is no obligation to provide information in certain circumstances, so where there's legal proceedings on foot, where legal professional privilege applies, where the Privacy Act applies, where there is a historic employment agreement, or where there is some other pre-existing document which might have confidentiality obligations. So we're engaging with the ABA to understand how the protocols are being used and how effective they are within the group of ABA members, but we're also engaging them and other industry associations in discussions around how the protocols can be extended more broadly throughout the industry.
I want to turn to asking you some questions, Ms Macaulay, about action that ASIC can take against the licensee. We've been talking so far about action against individual financial advisors. What powers does ASIC have to take disciplinary action against licensees?
So there's a range of powers. We have the ability to take civil penalty proceedings. We have the ability in the administrative area to cancel or remove licences or to place conditions on licences.
How many times has ASIC taken action against a licensee for a breach of Section 912 capital A of the Corporations Act and the general obligations contained in that provision?
So the remedy for that is a licensing remedy. So that would be either placing conditions on the licence or seeking to remove the licence. In terms of seeking to remove the licence, we have found that is a difficult process. I think there's been one occasion where we have succeeded. In a couple of other occasions, we've had short suspensions imposed on licences.
By virtue of breaches of Section 912 capital A?
Yes.
Okay, so one instance of expulsion referable to a 912A breach, is that what you said?
Yes, Morrison Carr, that's my recollection.
I'm sorry, I missed that.
Morrison Carr
Thank
was
you.
the name of the licensee.
And a small number of suspensions in reliance on a breach.
Two
Suspensions in reliance of a breach on Section 912 capital A. That's the entirety of the action that ASIC has taken in response to breaches of Section 912 capital A.
So we have taken other administrative action in relation to licensees that has ended in cancellation of the licences around things such as failure to lodge audited financial statements annually, failure to have professional indemnity insurance, failure to have a responsible manager or a key person insolvency. I just can't tell you at this point whether that we did that under 912A or there was another specific provision.
There are specific provisions that relate to those matters, aren't there?
Yeah, that's my understanding. I'm not sure if there's a provision for each of those things.
You've included a table at paragraph 43 of your statement that shows the frequency of disciplinary action against licensees.
That's correct.
I'll just wait till that's brought up. I think it's at 335. No, I'm sorry, we have it now, 0015. And that shows us that by far the most common action taken against a licensee is licence cancellation.
That's correct.
And do those figures we see in relation to licence cancellation, but for the one instance you identified, relate to matters such as failing to file annual compliance statements, failing to have a key person, failing to have professional indemnity insurance?
There are included within those statistics 4 instances where a licence was cancelled as a result of an enforceable undertaking, and I refer to that a bit earlier in my statement.
Yes. So 4 instances of enforceable undertaking, is that what you're saying?
Not because of a breach of an enforceable undertaking, but as a result of an enforceable undertaking, a licensee has agreed to cancel their licence.
I misunderstood. So the licensee has agreed to have their licence cancelled as part of an enforceable undertaking entered into with ASIC.
That's correct.
And the figures here include 4 instances where that has occurred.
They do, and in relation to some of those figures where the cancellation involved failure to lodge accounts or to have professional indemnity insurance, there have been elements of failure to properly monitor and supervise advisors, so that would be a 9112A.
Cancellation been in reliance on a breach of 912 capital A?
I suspect it's been done more in reliance on that a more binary factor, which is have the statements been filed, is the insurance in place.
Yes. Those are more specific
ascertainable obligations than the general obligations in 912 capital A, 12 capital A, are they not?
That's correct.
Okay. Now, how does ASIC tend to identify the sorts of action that you've referred to, non-compliance with the requirement to file annual statements, failing to have professional indemnity insurance, those sorts of matters?
So we've got a program in relation to lodging audited annual financial statements and auditors' report, where we, our registry area tracks the submissions of those and sends out reminder notices, and then after a certain period we get that data and engage with the licensees, ask them why they haven't lodged the documents. Sometimes it's not 1 year, it's several years. If they don't then lodge the documents, we commence licence cancellation proceedings.
So the vast majority of the cancellations recorded in this table relate to that conduct where you have identified as part of your program that the licensee has not filed annual statements.
I wouldn't say it's the vast majority, it's the majority, and then you need to add to that not being member of an EDR scheme, not having professional indemnity insurance in place, no responsible manager.
So, since 2013, over the last 5 years, what proportion of licence cancellations has been in relation to the provision of financial advice?
Those two instances that I referred you to.
And that's the entirety of the instances?
Yes, except other than to the extent that I outlined where it was part of other failures.
In what circumstances relating to the provision of financial advice has ASIC taken the step of suspending a licence in recent years?
So in relation to an entity called FTS, they had a program where they were putting clients into a double-geared strategy. So it was a cookie-cutter approach. It was a very risky strategy. So we became aware of that. We conducted a surveillance. We put together a brief to the delegate. During the course of that, the licensee ceased that strategy. We continue and put in place some other compliance arrangements. We continued with the hearing before the delegate. At the hearing before the delegate, evidence was put on by the licensee that they recognised that practice was bad. They didn't engage in it anymore. The other parts of their business were fully compliant, and so there was no need to protect the public by removing the licence.
So that was an instance where the licence was suspended, is that right?
Yes, it was suspended.
So that's one instance with one set of circumstances. Are there any others?
Yes, so the other instance was an entity called Masu. I'm just trying to recollect whether there was specific misconduct or it was more a general failure of the compliance and monitoring and supervision aspects of that entity's obligations. But in any event, again, the same thing happened as we were conducting the surveillance and engaging with the licensee. They put in place new compliance arrangements. You know, they may have put in place a new compliance manager. They may have got an external compliance consultant to provide assistance. And then the argument before the delegate was that whilst there may have been problems in the past, the problems are now all fixed. And so there is no need to make any order protecting the public.
So does that mean that since 2013, just 2 licensees have had their licences suspended in connection with the provision of financial advice?
Yes, that's correct.
And how long were the suspensions for those 2 entities?
In relation to the second one, it was 8 weeks, and I think it was 6 weeks in relation to the first entity.
And what were the practical effects for each of those licensees of the suspension of their licence?
Well, it would mean that the advisors who were authorised under that licence were unable to provide advice to the clients during the period of suspension.
And did those advisors find another way to provide advice during the period of the suspension?
My understanding is, yes, I don't have evidence of that, but what I understand would have happened is those advisors would have gone and used the licence of another licensee, either individually or en masse, because they needed to continue to service their clients during that period.
And do you mean another licensee connected with the suspended licensee?
Yes, it may well have been. So in relation to the first licensee, there was another licence held within that group.
So what was the practical effect of the suspension then, Ms Macaulay?
My view is not a great practical effect.
Another form of action that you refer to in this table is enforceable undertakings with a licensee. And we've seen examples of those undertakings against ANZ, respect of the fees for no service issue.
Yes.
Each of those required payment of a community benefit payment. What's the purpose of that sort of payment?
I think it's to mark the level of misconduct that was engaged in by those licensees. Remediation was addressed in a separate stream of work and is ongoing.
And how much was the community benefit payment required from CBA and ANZ in those recent enforceable undertakings?
It was, my understanding is $3 million from each entity.
$3 million from each to mark the level of misconduct. How did ASIC determine that $3 million was an appropriate figure for those community benefit payments?
I'm not really aware of that. That was not a decision that was made by me. I was aware of discussions around it, but I can't say how that figure was fixed and reached.
Do you think those figures were adequate given the size of those two organisations and the seriousness of the conduct that was the subject of the enforceable undertaking?
Well, certainly when you look at the balance sheet of those institutions, it's enormous. So $3 million is not a large amount of money at all.
To your knowledge, are enforceable undertakings with ASIC heavily negotiated?
Yes, they are.
And why does ASIC engage in this process of negotiating outcomes with licensees rather than exercising its powers to bring enforcement proceedings such as civil penalty proceedings?
In some instances, they can get a better outcome, not in every instance. So if what we're trying to do is ensure that good advice is provided to Australian consumers, and I think that's sort of the one of the general objectives of ASIC as set out in the ASIC Act, then engaging with a licensee to ensure that it puts its business on a footing where it is going to be set up and to enable its advisors or require its advisors to provide compliant advice, rather than simply levying a fine or even removing the licence. If you remove the licence, then the advisors will move on to other licensees who may not have good supervision and monitoring processes. So if we keep the business on foot, there is an opportunity for it to be improved going forward. There's also an opportunity for a remediation process to be put in place to look back at customers who've received poor advice and suffered a loss as a result of that.
Is ASIC concerned about a public perception of ASIC negotiating and reaching consensus with financial services entities about appropriate sanctions for their misconduct?
Yes, I'm aware of that public view. While you're correct that we do negotiate with them, ultimately we need to be happy. We accept what they offer, and there is a process of negotiation around that. But if they're not going to offer something that we think is appropriate, then we'll have an alternative action.
Your table shows that ASIC has taken no criminal action against any licensee in the last 10 years. Why not? I'm sorry, correct.
One.
There is one
Yes.
criminal proceeding that was instituted in 2010.
Yes, that's correct.
why only one criminal proceeding instigated over the last 10 years against a licensee by ASIC?
We'd usually look at the conduct of the individuals who are behind that licensee. The consequence of a criminal finding against a corporate entity is that there would be a fine imposed. We generally address the motivating minds of the corporation and their conduct, so that's the individuals who are involved, and so we would take criminal proceedings against the individuals.
And I ask you again, what about the value of public denunciation of the licensee for their conduct that comes with a criminal outcome imposed by a court?
Yes, there is certainly that.
ASIC hasn't sought that in all but one instance over the last 10 years. Does it not see value in that?
We weigh up, in any situation where we're thinking about what an enforcement or a regulatory outcome should be, we weigh up the various avenues we have available and the deterrent impact that they can have. So thought would be given to what you have said, the deterrent value of doing that. There would also be the issue that the corporate entity could be put into liquidation before the proceedings are completed. There's always the balancing exercise of where we place our resources to get impact, and so what is the impact of a criminal decision that may take 2 or 3 years to achieve, as opposed to perhaps using those resources to deal with some current ongoing conduct.
But on your evidence, the action taken by ASIC to secure a banning order against an individual takes roughly the same time.
Yes, that's correct.
And your table also shows that over the last 10 years, ASIC has commenced only 6 civil penalty proceedings against licensees, with 4 of those commenced this year.
Yes, that's correct.
So why so few civil penalty proceedings against licensees?
So the power only came into effect in 1 July 13, so
Yes.
that's the last 5 years.
Yes.
So you can only use civil penalty proceedings to address conduct that occurred after that date, so there needs to be a period in which the conduct occurred, so it may not have occurred right on the 1st of July 2013. ASIC then needs to become aware of it and take action. We have taken, it's essentially 2 sets of proceedings, while the 2018 figure says there were 4 defendants, and it's really been in relation to egregious misconduct that needed to be dealt with by way of a significant response, and some of the proceedings had injunctions as part of those proceedings as well to stop the conduct occurring.
Thank you, Ms Macaulay. I have no further questions, Commissioner.
Thank you, Ms Orr. Does anybody other than ASIC seek leave to examine Ms Macaulay? No? Mr Steele?
Just a handful of questions, Commissioner. You were asked some questions by the Commissioner, Ms Macaulay, about the speed with which jaw-dropping cases could be dealt with.
Yes.
In that context, can I ask
I
you...
regret that expression, aren't I, Mr Steele?
We're working with it, Your Honour. I'm sorry, Commissioner. In that context, can I ask you, to what extent do licensees commonly share information with ASIC as to the detail of the misconduct by advisors that's notified by them to ASIC?
Not often. So in some instances, there is no detail within the licensee other than the files or a complaints register. In some instances, there has been internal investigations of some nature conducted by the licensee. We find that there's a reluctance to share that. Legal professional privilege is often claimed, and also the fact that the investigation has not yet been completed, so there's no material to provide to us.
When ASIC gives a notice to a licensee for the report of the outcome of an investigation, for example, are such reports always provided in answer to the notice?
I'm sorry, are such?
Are such reports always provided in answer to such notices?
No, claims for legal professional privilege are often made.
You were asked some questions also about the importance of public denunciation in the context of
Yes.
misconduct by advisors. Does ASIC take criminal action against individual advisors?
Yes, we certainly do.
And in what sorts of cases?
Fraud or dishonesty cases.
And how frequently does that occur?
Very frequently. So if it comes to our attention that there is fraud and dishonesty and we can find the evidence, then we will take a criminal prosecution and we'll also ban the advisor. We'll generally take the banning action first.
And in the context of the distinction between the serious compliance concerns and other compliance concerns that you were asked about, you talked about the Advice Compliance Project in 2015.
Yes.
And that was a project in which ASIC gave notices to the big licensees, the 4 banks and AMP, to identify advisors about whom they had serious compliance concerns or other compliance concerns. Is that right?
Yes, that's correct.
And as a result of those notices, what number of serious compliance concern advisors were notified to ASIC?
My recollection was that it was somewhere around 147 reported to us by those 5 institutions.
And that occurred in the second half of 2015. Is that right?
Yes, I think so.
And how many other compliance concern advisors were notified to ASIC at that time?
I can't recollect the figure. I think it was somewhat more than 147.
Like 200 or substantially
Yes,
more?
no, around 200, I think.
Mhm. And that presented a body of work then for ASIC, one assumes.
Yes, that's correct.
And how was that work dealt with and over what time frame?
We're dealing with it now. So of those 147, we had a look at which advisors we had already banned, and there were a significant number where we had already taken action or there was action on foot. We then did some preliminary, we looked at which advisors were no longer in the industry. We did some preliminary inquiries of the other advisors in an attempt to assess the seriousness of the misconduct, and then those remaining about 60, we are slowly working our way through doing a banning action. Most of that advice is now somewhat old, and we need to have a look at more current advice and make an assessment of whether the poor advice practices are continuing.
When you say slowly, what's dictating the pace at which you're able to do that?
Well, what I outlined previously, so we need to gather material, we need to put together a brief of evidence, we need to provide it to the delegate. So we've got a team of about 8 people doing that. We've got streamlined procedures. One of the things that we do as a rule there is call the advisor in at the end of our surveillance and put to them all of the issues that we find that helps in getting the outcomes.
And you said in answer to one question from Council Assisting that ASIC had found it difficult to get licences cancelled for contraventions of
Yes.
Section 912A obligations.
Yes.
Can you explain how and why it's difficult?
Because licensees, when they become aware that they are subject to this kind of surveillance and banning action, put in place arrangements to improve their compliance. We then need to, in essence, start the surveillance again to assess what those compliance procedures are, if we've got concerns about them, because otherwise when they come to the hearing before the delegate and say, well, the problem is fixed, there's no need to protect the public. So it becomes an ongoing course where we would need to pursue the licensee as they put in place new arrangements.
You were also asked some questions about the number of civil penalty proceedings that ASIC has taken in recent times
Yes.
in this area,
Yes.
and why enforceable undertakings are sometimes preferred to civil penalty proceedings.
Yes.
Is it possible for ASIC to take civil penalty proceedings in relation to a breach of the obligations in section 912 capital A?
No, at this point in time.
When you say in this point in time, what do you mean?
Well, I understand that the Enforcement Review has had a look at this, and a recommendation has been made that that power be provided to ASIC, and I understand it's been accepted by the government.
You were also asked some questions by Council Assisting about the $3 million community payments that were included in the enforceable undertakings in relation to a couple of the fee-for-no-service licensees.
Yes.
Remember that? Do you know what the level of penalties would be if ASIC took proceedings in relation to that matter?
It would be certainly less than $3 million. I'm not sure off the top of my head.
And is it your experience that the level of penalties...
Sorry, on what do you base that? Ms McCauley, are you saying that there's a maximum that would be engaged, or are you making a prediction about what the court would do? What's the...
Well, I don't think I can make a prediction of what a court would do, but I'm imagining that it would be, if it was treated as one contravention, the maximum penalty, I think, is less than $3 million. And now there's a question about how many contraventions there have been.
I should say I'm a little surprised by the answer, but perhaps it's so. I haven't looked at it.
Perhaps it might be something we could take up in submissions.
Yeah.
Is it your experience, is it ASIC's experience, that the level of penalties provided for in the current regime is adequate to effectively punish and deter wrongdoers in this area?
No, it's not adequate.
No more questions, thank you.
Yes, thank you, Mr Steele. Ms Orr?
No, thank you, Commissioner.
Thank you very much, Ms McCauley. You may step down and you're excused.
Commissioner, as I said, Ms McCauley was the last witness in this hearing block. There are, however, some documents I wish to tender before our closing statement.
Yes.
These are additional documents that we or AMP consider may be relevant to the AMP Fees for No Service case study. A number of these documents were provided to the Commission by AMP over the weekend prior to Mr Regan giving evidence and have now been reviewed. The first of those is AMP 6000 0006 2286, minutes of a meeting of the Board of AMP Limited on 16 December 2017.
That is Exhibit 2.249.
The second is AMP 6000 0052 1607, an email from Nicholas Mavrakis to Brian Salter, dated 15 October 2017, attaching marked up pages of the Clayton Utes report.
Exhibit 2.250.
The next is the attachment to that email, AMP 6000 0052 1608.
There's Exhibit 2.251.
AMP 6000 0054 6721, an email from Brian Salter to Nicholas Mavrakis and Larissa Baker Cook, dated 11 October 2017.
Exhibit 2.252.
The attachment to that email being a Section 33 notice from ASIC dated 6 October 2017, AMP 6000 0054 6722.
Exhibit 2.253.
A second attachment to that email, being an attachment to the Section 33 notice, a paper prepared by Brian Magellan titled FOFA Practice Proposition Stream, Orphan Contracts, Policy and Process Changes and Recommendations, AMP 6000 0054 6732.
Exhibit 2.254.
AMP 6000 0054 6816, an email chain between Brian Salter of AMP and Tim Mullally of ASIC, dated 18 October 2017.
Exhibit 2.255.
AMP 600000547532, an email from Brian Salter of AMP to Tim Mullally of ASIC dated 7 February 2018.
Exhibit 2.256.
AMP 600000547602, a letter from Tim Mullally of ASIC to Brian Salter of AMP dated 14 March 2018.
Exhibit 2.257.
AMP 600000548616, a letter from Brian Salter of AMP to Peter Kell of ASIC dated 14 November 2017.
Exhibit 2.258.
A notice issued by ASIC under Section 33 of the ASIC Act dated 9 January 2018, AMP 600000565796.
Exhibit 2.259.
An email from Larissa Baker-Cook to Nicholas Mavrakis and Edmund Park dated 12 September 2017, AMP 600000622748.
Exhibit 2.260.
An email chain between Larissa Baker-Cook and Nicholas Mavrakis dated 25 September 2017, AMP 600000626260.
Exhibit 2.261.
An email chain between Brian Salter and Nicholas Mavrakis dated 8 and 9 October 2017, AMP 600000627596.
Exhibit 2.262.
An email from Nicholas Mavrakis to Brian Salter dated 9 October 2017, AMP 600000627702.
2.263.
An email chain between Brian Salter and Nicholas Mavrakis dated 13 October 2017, AMP 600000628482.
Exhibit 2.264.
An attachment to that email, AMP 600000628247, being an email chain dated 6 September 2011 between Tom Galetta and Maria Corpel.
Exhibit 2.265.
A second attachment to that email being AMP's internal audit report dated 18 October 2011, AMP 600000628252.
Exhibit 2.266.
An email from Nicholas Mavrakis to Brian Salter and Larissa Baker-Cook dated 16 October 2017, attaching the final report of Clayton Utes dated 16 October 2017, AMP 600000628584.
Exhibit 2.267.
The attachment to that email being the final report of Clayton Utes dated 16 October 2017, AMP 600000628585.
2.268.
A Microsoft Outlook schedule acceptance of meeting to take place on 17 August 2017, AMP 600000617848.
Exhibit 2.269.
An email from Larissa Baker-Cook to Nicholas Mavrakis and Edmund Park dated 13 September 2017, AMP 600000622774.
Exhibit 2.270.
An email from Nicholas Mavrakis to Brian Salter dated 4 October 2017 regarding Bowler Report revised draft, AMP 600000521097.
That's 0052, is it?
00521097.
Exhibit 2.271.
An attachment to that email being a report incorporating changes in markup following discussions with Catherine Brenner, AMP 600000521098.
Exhibit 2.272.
An email from Larissa Baker-Cook to Nicholas Mavrakis and Edmund Park dated 24 September 2017 regarding final draft of the Bowler report, AMP 600000626108.
Exhibit 2.273.
An email from Brian Salter to members of the board dated 15 October 2017 regarding update on the CU report, AMP 600000758381.
Exhibit 2.274.
The attachment to that email being pages of the Clayton Utes report updated with updates in markup, AMP 600000758302.
Exhibit 2.275.
And finally, an email dated 15 October 2017 from Nicholas Mavrakis to Brian Salter regarding liability under the Corporations and ASIC Acts, AMP 600000628472.
Exhibit 2.276.
That concludes the evidence that we wish to rely on this block of hearings, Commissioner. Perhaps if we could have a brief break to reset the bar table before the closing statement.
When do you want me to come back, Ms Orr?
At past, if convenient to the Commissioner.
11:30 it is.